for people to represent themselves in their own causes or actions in courts. But in the words of Abraham Lincoln, the man who represents himself has a fool for a client. Today on Law Express, we explore self-representation in people's suits, disputes, or actions in the court system. My name is Noella Seydu, and this is Law Express. We'll go for a quick commercial break. When we return, you get to meet my co-panelists on the topic self-representation. Don't go away. This is Law Express.
Theophilus Donkor is a legal practitioner who is passionate about the law and dedicated to providing expert legal counsel. In his free time, he enjoys reading and engaging in regular exercise routines that keep him energized and focused. Xavier Cudjoe is a private legal practitioner who finds fulfillment in a variety of activities. When not engaged in legal work, he delights in reading, tuning into the radio, tending to his garden, and contributing to community service initiatives. Noella Seydu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
Every person under our laws has a right to represent himself in court and also be represented in court by a lawyer. What I mean by this is that if you're a non-lawyer and you have a matter in court or any legal matter even outside the court, you can decide to take it up yourself without necessarily asking for the help of a lawyer, probably at a fee or even free. Lawyers themselves too, even though they are lawyers, trained lawyers, if they have matters in court, they have a choice to make, either to hire another lawyer to defend them, which we have seen around us, or they themselves can decide to take it up. And this is not limited to only matters in court. When it comes to agreement, let's say tenancy agreement, you're a non-lawyer, you can decide to draft one. We've seen it a number of times. And from a practical experience, I don't remember the last time a client asked me to draft an agreement from the scratch from him. What they would rather prefer to do is to do a draft and say, lawyer, can you look at this for me? That kind of thing. And sometimes you try to advise and say that this provision in the agreement appears inimical. The answer will be, oh, we've been using it all this while, so I like it that way.
Life is full of choices. And when it comes to legal representation in court, it is a choice for you to decide as to whether to conduct your own case, your own cause, or your own matter before any court or any tribunal or arbitration. So the law does not necessarily mandate you. The only instance where the law is mandatory is when the person in court before the law court or anywhere is a company, where the law requires that the company should be represented by a lawyer. Apart from that, individuals as we are, when we have a matter before a court, a tribunal, whatever it is, you are allowed to represent yourself. And that representation comes with a lot of advantages and disadvantages.
Great. So we're looking at representation before the judicial system.
Yes.
And I think it's important to demarcate where the representation is being done by a lawyer and where it is done by a non-lawyer. Okay. Regardless, you've already established the fact that self-representation is one of the options available to people within the legal system. So probably let's zoom into the representation by non-lawyers. What are the pros and cons? What are the challenges you're likely to face?
Well, I would say that the obvious advantage you have as an individual who is not trained in the law, representing yourself before a law court or a tribunal, will be to cut down some costs in terms of legal fees.
Yeah.
I say this because if you are not a trained person in the law to understand the workings of the law, it may pose some challenges. For instance, do you even know when to raise an objection when an unfair question is being asked of you? Or do you know which questions are relevant for you to even ask in the law courts? You may think that the questions you are asking are relevant. For all you know, that is not the core of your case, even though the court is there to guide you, but the court is not there to do the case for you. So I think that, yes, you may have the advantage of cutting down costs, but you may also have to look at the other side. Are you well trained or well versed in the law to the extent that you can do it as well as a lawyer would have done it for you?
So you might end up saving costs.
But yet at the end of the day, your expectations may not be met.
Or you actually end up raking in more costs.
Oh yeah, it's possible. Because if you lose a case, costs will be awarded against you. Even beyond the cost, once you've expended some time without expending money, you could have used that time to do some other work. But here is the case where you have expended that whole time before a court doing your own case, but because you lack understanding of how the workings of the cost are, you end up losing the case and you'll be mocked in cost, and all that put together may be a higher cost to you than even going to a lawyer for him to be paid for the work to be done for you.
Great.
One of the advantages that comes with self-representation is that the individual will think to understand the fact that I know my case, this is the way I want to represent it, this is the way I want to present my case to the court. So the individual will feel vindicated that I've had an opportunity to present my case the way I want it. Unlike the lawyer will say that these are irrelevant, these are relevant, ignore this. But times people come to court because they want to express that emotional bit of the case. Mm-hmm. They want to be understood by the judge. Yeah. So when they have the opportunity to represent themselves, they're able to say that this is what I want to say to the court, and I've had my day in court. But this advantage that I've talked about, people also think that they are able to express their emotions, because that one, you are not guided by a lawyer who will always remind you that emotion is not part of the game. Yeah. But what you need to do is evidence. So, but all these things come with a risk, because when you get your emotions involved, it takes away the substance of the case. You are not even able to focus on the case itself, but you are talking about things that matters to you. It might be petty, it might be something the court might not be interested in, but you are thinking that, oh, I have my day in court, I've said it. This my auntie, she has been doing all these things, I've tolerated her all this while, but today I went to court and I said it the way I want to say it. People are free emotionally.
So they feel vindicated.
They feel vindicated. It's one of the advantages.
But this emotional bit that you mentioned, to add on to that, might actually be beneficial to your case. It depends on the kind of case. If, for instance, a criminal matter, we all know the judges are still humans at the end of the day. If a lawyer in his stoic manner is explaining your case and going a methodical and, you know, with all the legalese, without any emotion, maybe you as a party, when you come there, even with witnesses, some of the occasional tears might sway things. It might increase the cost and all of that. So yes, it's a con, but maybe, just perhaps, sometimes it could inure to the benefit of your case ultimately. And self-representation, in my opinion, affords you the opportunity to do away with the buffer between the bench and the parties. So the lawyer stands at the bar and is in between, you know, the well and then the bench. So you are representing yourself. Yes, you cannot approach the court by going to the bar where the lawyers sit, but then you get closer than everybody else would, right? And then you can get to address them. And I've learned over the years that the judiciary or the bench is more tolerant or friendly towards people who are representing themselves, because they understand that these people don't know the rules. They understand you don't know the timelines. So perhaps if it was a lawyer who was to file something within a time frame, they may be heavy-handed in saying, look, you have failed to meet your timelines, and so we'll go ahead. But you see, when it's individuals representing themselves, they are likely to say, okay, you have one more chance. Go and then get this done. Do you understand what this is about? They are more likely to say, I hope you understand that when you say this is on oath, and these are the implications and all of that.
The judges may, or the court may be tolerant when it comes to those things, giving you or not allowing you to meet deadlines, as may be the case when you have a lawyer. But that does not add to the strength of your case. If your case is bad, it's bad. Emotions, yes, you can express emotions, but the judge too is there not to pay too much attention to emotions, because the judge is applying the evidence, the law to the facts and the evidence before him. So you may be emotional. You think that all what you're saying is that, oh, I've bought a land, for instance, I've registered it, and that is the end. For you, once you've registered the land, it is your land. For all you know, the person you bought it from doesn't even own that piece of land, let alone selling it to you legitimately. So I don't think that emotions alone is enough. I would advise that to be able to take the courageous step of representing yourself, you should be able to understand the workings of the law. It is not about calling 1,000 witnesses or saying so many things in court that makes your case a good case. If it is bad, it is bad.
But you would know that many people do not just go solo in self-representation, especially with people who are not lawyers. There's always some clerk, some registrar, somebody in some corner who is coaching some law student somewhere, or some pocket lawyer in the neighborhood that is helping the person to draft, helping the person in terms of how to address the court, what to do. It's not sufficient, but we can't discount that fact.
I'll give you a practical example. I have done it recently for a personal friend who is a surveyor in a divorce matter. The wife was the petitioner, he was the respondent. So after the matter was done, if I recall, he was supposed to be paying some money for monthly maintenance of the children of the marriage. And I think the lady went back filing another process altogether, and then because he had defaulted in paying. And I advised him that is not done. So he should be advised that if the court makes an order and she feels the order is being disobeyed, it is not another process in the form of a petition that you file, but you try to enforce the orders of the court using a court process and not the petition. And I think he went, the court upheld the advice I gave him, and they threw the new process filed. New orders were made that she could only ask for an enforcement of the payment.
So that's another disadvantage in representation.
Okay, let me go back to where you said the buffer between the judge and the party is taken away in self-representation.
To some extent, not entirely.
What it means is that the lawyer takes away the case from the party when he comes to court. Apart from the party giving evidence, the party does not get involved in the process. In instances where we have done cases where the judge has even asked us to address him on law, that one the party doesn't even get to testify. So he doesn't get involved. So when the lawyer is involved, the case is taken away from the party himself or herself, and then the lawyer takes over. What happens is that when the party is also involved, the judge gets to address the party directly. So he gets to understand the workings of the court. The judge will not be using legalese. There are instances you close from court and you have to organize a whole session to explain to your client what happened, what the judge intends to do. There are instances they will tell you that they heard something different and you are telling them something different. There are instances my clients have had issues based on what the judge has said and what they purport to hear.
Because they didn't understand
it. They didn't understand it. So in that case, the judge also becomes part of the society because he's able to communicate with the parties directly, telling them what they are supposed to do and not using legalese.
Yeah, I totally agree with you. And it's also because when you take a lawyer, you have engaged a mouthpiece, and that becomes your rep, your representative in court. So you cannot be addressing the bench or talking to the judge directly. You need to go through your lawyer, unless the judge specifically speaks to you. They want to have a lawyer in place, but when it suits them, they want to address the bench. So every now and then you see parties trying to talk to the judge, and mostly the judges will redirect them, talk to your lawyer. Then your lawyer can address. But where it is self-representation, then you don't encounter that. Automatically, you can have a back and forth in communication with the judge.
But I must add that self-representation does not necessarily have to be at the initiation of the action. You can go with a lawyer along the line. You decide to represent yourself. All you need to do is to come for your file from the lawyer. Or if the lawyer, does, maybe based on your conduct, he says, I'm no longer interested, then you have to file a
perhaps
process.
he can just afford it anymore.
Very well. So you can go ahead and say, oh, today I'm here alone. Then the court can give you time. Oh, you don't have a lawyer any longer. Do you want some time to find another lawyer? Or it appears I cannot afford a lawyer any longer. Then they will give you time to come back and continue with your case. You can even do that and still go back for another lawyer.
Yeah.
So it's not as if you start with a lawyer, you must end with a lawyer, or if you start yourself, you must end that way.
We've been making it look so glossy in terms of self-representation, especially for the non-trained person, where you are a private citizen, you're not trained as a lawyer, and you come before the courts. It's our duty to let our viewers know that it's a very risky step to take. Yes, you have the right. Yes, it is your choice. But when you look at what could potentially happen to your case, as against when you are properly represented, it's like day and night. So it should only be in extreme circumstances where you have no options. Your hands are tied and you have to go solo. But however necessary, like whenever it's possible, make sure you have a lawyer in court with you. And that's why the law provides for even legal aid. If your sole reason is that you don't have money and you can't sustain it, the law provides this service for you, or the state provides this service for you, so you can still get a professionally trained lawyer to help you push forward your case.
I think apart from the money bit, you must be emotionally strong to be able to do that. Because we are all emotional people. The way you subjectively assess your situation as far as a case affecting you is concerned may be different from a neutral person who is a lawyer who will be looking at it. Because you are looking at how long it takes you to save money to do this, and all of a sudden this is the end of it. The lawyer can give you an assurance. It looks like that, but it's not like that. But you may think that that's the end of it, so you get to court. You are just saying things because your thoughts may be clouded so much with emotion. So I think that it would be advisable that only in extreme or especially extreme cases that people should try self-representation. I don't think lawyers in Ghana are that expensive. You can always afford them because
that's
somebody's brother is somebody's church member or old school boy and all that. So,
and of course, there's always legal aid.
I think that the issue of self-representation is very dangerous. The dangerous situation is that when you make a mistake in law, it will be difficult to correct at the courts. You might say that you have your day in the Court of Appeal, the Supreme Court, and even review. But once you make a slip, you cannot, some of them, there's nothing you can do about it. And before you even approach the court, you need a professional to tell you that whether you can approach the court, which we call the course of action, whether it has accrued to you. And is this the proper court to approach? Is it the proper process to use? That is why you need the services of a trained lawyer who has been trained. I have had the chance to work at the court. So you look at processes, oh, there was this particular case, this is the way the lawyer did it, so we go and put the template and give it to the person and mold it along that line. But the industry, the case law that the lawyer relied on, or the facts of that particular case, might not be the same as the template you are looking at. So it comes with its own disadvantage. So I want to encourage each and every one of us that there are so many lawyers in Ghana who are not expensive, as my senior has said. So that we don't, the workings of the court is different. It's regulated. It's a regulated area, which we must all understand.
On this advisory note, lawyers don't come cheap. But we'll go for a quick commercial break now, and when we come back, we pick up the conversation from where we left off. This is Law Express. Don't go away.
Self-representation is good, is your right, but I would not advise anybody to make that a first option, because there are a lot of technicalities when it comes to matters, especially in court. There are deadlines. As my colleague said, to even know that this is a matter that is good for court, so to speak.
And which court?
In which court? Because we have various categories of courts.
Yeah.
Because if you take the first step and you fail, that is there's something we call invocation of jurisdiction. If you don't do it well, it means that the court cannot hear you.
Yeah.
And also there are timelines. There are certain cases you can file after a certain period of time. If that period lapses and you want to go to court, it's only a lawyer who can tell you, oh, you stayed back too much. So
yeah, so you have a good case,
or
but
you don't have
you are late.
But you are late.
Yeah.
But you may not understand. You just go to the court will tell you, oh, I can't hear you because you are coming in too late.
Yeah.
There are instances, even in court, when you receive a court document from another party, there's a period that you have to respond to it. If you are not able to meet that period, it becomes a problem, because once you are not a lawyer, you take everything for granted. Sometimes you even see processes posted on your wall. For you are just removing it. When you remove it, where do you go with it? Do you take it to court? Or even they come and serve you a process, your name is on it, but you don't know anything about the case. Do you keep it? Or where do you send it to? All this, you need a lawyer.
Yeah.
Once you receive a process from the court and it is not meant for you, my advice is that send it back to the registry of the court, because it is not yours. Yeah. For the court to redirect wherever it's supposed to go. But if you take it, it means you take it to fight and you have to respond.
There's also the issue about the timelines that you need to learn the rules of the court. The lawyer has spent all his life learning these rules, and you want to learn these rules and apply them to your particular case within a short time. When there are timelines, for instance, if a rate is served on you, you need timeline to enter appearance and file defense. If there are other interrogatory matters that have been applied for by the party, you need to respond. How do you respond? For instance, if there's an injunction, you don't know that, you need to, apart from your affidavit and your exhibit, even how to arrange the exhibit, you need to learn it. It's something you learn by practice. You need to add your argument. How do you get those arguments to buttress and add them and file? If you don't do these things, because now before you are learning the rules, it will be difficult. You will always be late, and your processes will not catch up, and the judge will not wait for you, even though the judge is a little bit patient when it comes to people who are not represented. But the judge is an arbiter. It is not like the civil jurisdiction where the judge is involved in the trial, in the procedure. But our case, in the common law jurisdictions, the judge is a neutral arbiter who is watching and only giving directions as to what must be done. So the timeline for learning will catch up with you. You will not be able to. And then the timeline to be filing process. The rules are there. There are timelines. When you do this particular thing, within this particular period, you are supposed to do A, B, C, D. So if you don't know them as a lay person, you will always be found wanting. And before you realize, there are instances I've done cases where you realize that the cost involved is virtually equivalent to the claim the person was claiming, because the defendant was not following processes and cost was being awarded against him at the district court. Yeah. So we realized that at the time we finished, the cost against him is equivalent to the claim the plaintiff was claiming.
So now it's like double
the cost. So it is expensive for you to be conducting your own case in another vein, because there are instances you can go to work, the lawyer can go to court for you. There are instances you can do something, the lawyer will go to court for you. But if you are doing your own case, you need to be present in court at all material
Well, I
time.
think even with your own matter where you have representation, it's important to be present at all times.
All times.
Or to be represented, by somebody else. But I like to liken this whole situation to self-medication. So you are ill, and instead of going to the hospital to see a doctor, you decide to walk into a pharmacy to procure your own medication and try to treat yourself. It's just the same way. It's like blindfolding somebody and asking him to fight with somebody who is not blindfolded. That's just the picture in self-representation by people who are not trained for purpose. So let's now move it to self-representation by lawyers themselves. This time, you have the training all right. You are a lawyer. You understand the rules. You understand the technicalities. But it is your case. You are the party involved. I know both of you have done this, so you've represented yourselves in court. So I know I might get a very biased feedback today, but I haven't done that, and then probably I'll just be the neutral person here. What is your take on this aspect?
But before we get to the lawyers, the non-lawyers,
Yes.
you get judgment. Even lawyers, when we have judgment, enforcing it, getting the fruit of the judgment is very, very, very difficult. Okay. So you can go to court, the judge will grant you judgment, all right. But how to enforce it? I have a judgment that the person has been trying to enforce for the past 10 years. He has not been able to enforce it because every step of the way he takes, he makes a mistake, and we have to revert to the status quo of the judgment. So for 10 years, he's having the judgment, he cannot enforce it. So you can go to court, all right, the judge will be lenient and give you judgment, but how to enforce it?
So you're looking at post-representation after you have now gotten judgment. What are the next steps? And I'm sure people do not even pay attention.
It's a very technical area.
They assume that once you've won, you've won.
You won.
But nobody is going to write a check and put it at your doorstep. No. You need to take steps to get what you have won. I know I introduced the issue of representation by lawyers.
Yes.
Okay, but it's time to go to the streets of Accra. We sampled people's opinion on the topic. We'll pick that reactor rate and then we get into that aspect of the conversation.
Myself in court because I'll have to take their responsibilities as a lawyer would do, which is filing documents and then other things. So for me, I would not represent myself in court.
Of course, I can represent myself in court because I am bold and confident. Since it's my own case, I can defend myself best.
Personally, I wouldn't love to represent myself in court because I feel that's the work of a lawyer. Though I know much about my case, I feel the lawyer knows better and will do his work well.
No, I won't represent myself in court because I don't have more knowledge about law. Lawyers are those who have more knowledge about the subject, so I will leave it for them to do it.
Yes, I will represent myself in court because it's my case and I would have to defend it and give a detailed information about the situation that happened in the court.
The second person in the video on the street of Accra stated that he is bold and confident so he can represent himself. There are instances you go to court at a certain level, you don't even talk. All that you need to do has to be written, we call it written submission or written address. You do those things and you just file it and the lawyer goes to court and the judge gives a date for a judgment. So it is not about how confident you are, how bold you are, how you can express yourself. You can be expressing yourself, but what you might be expressing yourself to the court will be irrelevant. The court doesn't need that particular thing. There's something based on what you are asking the court to do for you. That is why, if you look at the election petition, we all know that they will keep on telling us that they did not provide enough evidence or the evidence or the rules of the game is evident. When they say evidence, it's not every evidence. It depends on what you are asking the court to do, that you bring that particular evidence to support what you want the court to do for you. So it is not about you being bold or you being courageous or able to express yourself. It goes beyond that. It is a technical area that we must all admit that even your emotions... But
counsel, let's not discount being bold as a very good attribute. I mean, even for you as a lawyer, being bold helps. You've seen lawyers shake very much in court. You know, shaking all over because timidity doesn't work in this game.
As a lawyer, as part of the advocacy. But what I'm saying is that the lawyer can have all these even attributes. If the law is not good or the facts are not on his side.
You haven't seen a lawyer who has a bad case,
I know
bad
you
law,
can, yes.
And it's just bulldozing his way with good English and confidence.
I've had a case where the judge told me that for 20-something years, He has never granted an ex parte application, but I convinced him on that day to grant it.
See?
So when we came back for the notice one, he told me blankly that this time round, the other party is here and I must convince him. So he, before he gave his ruling, he said this is the first time he had actually granted an ex parte application because
so you agree with
the
the guy?
boldness and the flair, the confidence as an advocate or anybody who is before the judge. Because
It's
you have
an
to be
asset.
persuasive.
It's just an
You
asset.
you are persuading the judge. So these are assets that you can use. But what I'm saying is that you can have all these attributes, but if the law is not on your side and you have a good judge, you do all these persuasive things, but he will tell you that this is what the law
Listen,
says.
you have nothing to lose with being brave and courageous,
courageous.
okay?
Yes.
Because look, even if your case is bad, your law is not lined up or in alignment with your case, and you are still brave and bold and you deliver beautifully, you might just
It
win.
sways-
You might just win some other new clients who probably do not understand what's going on in the court.
And
They are
I-
going to go out singing your praises like that lawyer is excellent, but they won't even know you just lost the
They
case.
may be saying that out of ignorance.
I don't discount the issue about you being confident and bold. There are instances the judge will grant you your application and realize that he has made a mistake in his private. If you have conversation with judges, they will tell you that there are instances you came to confuse him and he granted you, but upon second thought, he realized that he made a mistake so there are good attributes, even for the lawyer, to be able to convince the judge. But that is not all that you need. You also need
We
the
still
law.
haven't touched on lawyers representing
Lawyers.
themselves.
Okay.
And some people may argue that once you're trained and it takes away the issue of the technicality, the challenge with technicality, then what is the challenge? You should be able to do that as of right. But I still think that there are some drawbacks in
lot.
representing yourself. At this point, it's no longer a sick person going to the pharmacy to procure medication. It's now a doctor trying to treat himself. So you're trying to perform surgery on your own body, which to me is logically impossible.
The thing that will take away the lawyer from his case is his emotions. Your emotions, even we as lawyers, even we are trained that our emotions should not be part of the case. There are instances when your emotion, you realize that I shouldn't have said this in court.
Yeah.
I made a mistake. Next time I will look at it. The things that I used to say in court 10 years ago, today I will not do them
Out of
because
experience.
I've gone through experience, I've gone through a process. I've now taken away my emotions from the case. I now know that the case is not my case. I'm only an advocate trying to help the person to conduct his or her case. Instances I've conducted my own case, I've realized that my emotions have taken the better part of me as a lawyer. I think that
So regrets?
I have a regret.
And would you,
I will not repeat. There are instances.
so this is where you hire me, right?
Yes, there are instances the lawyer will tell you that I told you this tangent you were going was not right.
Yeah.
In the midst of the argument, you say certain things and you realize that
At that point, it's a survival thing.
yes,
you
you
want
are
to
looked
win.
at, you want to win, and you realize that that has rather taken your good case away from you to the
Yeah.
ditch. So I think that as lawyers, I will never, at the highest level, I will
You
not.
won't do that again.
I won't do that. Even if at the Supreme Court where I need to only write submissions, I don't do them
I mean,
again.
the submissions are almost like arguing viva voce, but
Yes.
this time you've put it on
Okay.
paper.
Your emotions.
So you can still write things that you ordinarily wouldn't write, and that's even more dangerous because you're not saying in a way where the judge can choose to ignore.
No, ignore it. But it's before
it's-
the judge. So
and
you
it's on
cannot-
record. I think it's just, for me, I always believe that it's better to get somebody else to take up your matter. But let's hear from Mr. Kuji, because he is also somebody who likes to represent himself, and I believe he's currently representing himself in court.
Yeah, right. I have done one for myself. I'm currently doing two for myself.
Okay.
I try as much as possible to be objective in whatever I do. And in that regard, emotions do not set in. But you know, as lawyers, our practice hinges on consulting each other. So I'll sell my case out. This is what I'm going through, but this is what I'm doing. In court, you would meet colleagues who said, oh, But why don't you allow me to do this? The answer I simply say is I don't have the money to pay you. Because this is a very
What if
stressful.
they opt to do it pro bono?
I'm not sure they will do it well, because Theo here is my very good friend. Assuming Theo has $1 million application before the Supreme Court,
Okay.
then I will be telling him about land in Oyarifa that cost me just about 100,000 Ghana cedis. Clashing the same day, I bet you he's human. He would go there and write a letter this way.
Maybe relationship might make him pick your side.
I don't see that much working in Ghana from my little experience. So any day, any time, depending on the nature of the issues, I will continue to represent myself. But what I would do is that in doing my research, I'll consult friends.
Okay.
If I'm not too sure of something. And I wouldn't like to talk
But
too
what
much.
about the emotional bit?
The
Because
emotional
it's
bit-
you. Maybe you have some sentimental attachment to that particular thing you're litigating over, and you're in court. Yes, I respect the fact that you're a very senior lawyer. You've been on this road longer than the two of us, and you might be calm and collected. You are a gentleman, but when it comes to a survival situation, this is about you. It's about your reputation and all of that. Is there no possibility that you might tilt a bit towards
so
the
far,
bad
those
side?
that I've done do not or did not hinge on reputation. But as I said, as much as possible as an individual, I try to do things devoid of emotions. That is why even if you are my cousin and I'm advising you not because you are my cousin. I see you as a client. So whatever is not true, I'll tell you is not true.
I'll say this though,
Yeah.
that perhaps
Yeah.
the cases you have handled so far personally
Yeah.
are such that you could get away with them. But there's always that one case
Yeah.
where you know that at this point, somebody has to step in for you, depending on the nature.
That's why I said that,
depending
the
on
nature of the case.
Because it's at that point, just consulting will not cut it. You might need a lawyer who is dedicated to just that aspect of practice to take charge
Yeah.
of the situation.
I agree.
We have some questions coming in by way of social media.
Very well.
Before
would-
that, I want to talk about what my senior just said.
Yeah.
Emotions, you cannot discount it. I have a process. My senior has never, no matter the nature of the work you submit to him, he will always tell you good work, but look at ABC. But when
Of course,
took,
second opinion, and
when
all
when I took-
professions do that.
when I took a particular case I wanted to file at the Supreme Court to him, he just wrote the email, rubbish. Go and look at it. Because it is something that has happened to my client. And I will explain. My client was charged with a particular law. But under Act 30, when the prosecution is able to prove other offenses, then he will be convicted on it.
Yeah.
So I thought that it was wrong law. And I was peeved the judge convicted him, because my argument was that we should know the case against us. That
And
is the
what punishments you are
defense we
likely
have
to face.
fashioned against it. And we have
Yeah.
defended that particular charge to the end. But they were able to prove another charge against us. So I wanted to take it to the Supreme Court. But because I was
you were not
involved,
charged with that particular one, yeah.
because I was involved, my emotions got into the submissions. And he said that the email he sent to me was that this is rubbish.
Well, maybe you were not being sane
emotion-
at that point.
No, at that point, my emotions were
clouded your
in
thoughts.
it, because
Yeah.
I was using that particular client to go to the Supreme Court. So the case is still pending because he has not looked at it.
Let's check the social media questions and we can pick up from where we left.
Thank you, Noella, for putting together this educative program. My name is Payako from Elmina. I'm dealing with a personal injury claim after a car accident. As I prepare for legal proceedings, I'm contemplating whether to represent myself in court or hire a lawyer. What are your thoughts on self-representation in personal injury cases like mine? Are there particular risks or benefits I should consider when deciding whether to handle my case independently?
I was not paying attention the whole time because this entire time we've been on the show today, it's been about the pros and cons of self-representation. So should we
Or
refer
maybe
part
he joined later.
should we
in the-
refer part to the YouTube link later?
I would still advise him to, because it's personal injury, he should look for a lawyer.
Yeah.
You should look for a lawyer.
Because of the emotional issues.
I'm not providing advice on this program to
you don't
him.
give free advice on
I'm not by par. What it is that you don't even know the parties to sue in this matter. Even this personal injury, you can even resolve it out of court if you have a lawyer. The lawyer can write to the insurance. They will bring a proposal. You look at it. If you are amenable, you settle it at that level. So it is a whole lot.
It's always difficult to just pick a paragraph of,
yes.
And then decide or offer advice from there.
So around Elimina Cape Coast, there are lawyers around.
Yes,
so you can
just
look
find
for a
one
lawyer,
and then give
because
better details.
Personal injury, you have some deformity, which as a person,
he hasn't told us that
yes,
also. So you see, there's a lot to fill in.
So your emotions and other things, you didn't know the law. You didn't know the law as to the persons even to take to court.
Yeah.
So seek the services of a lawyer.
Dear Noella, I would appreciate it if you kept me anonymous. I'm facing a complex legal situation involving marital assets, child custody, and spousal support. My spouse and I have been married for 10 years and have 2 children. The main issues in dispute include the division of property, determining child custody arrangements, and establishing fair spousal support payments. I don't know whether or not to represent myself in court. What are the potential drawbacks of representing myself? And how might it impact the outcome of my case? Thank you.
In the first answer, look for a lawyer because you have already said you have a complex marital issue, and this is obviously emotional. So our advice that she look for a lawyer so that the issues will be dealt with.
I see a mix. So there's divorce, there is custody, and then there's maintenance, and there's also assets, division of assets, and all of that. It also suggests that if you have assets to divide, it means you can afford a lawyer, potentially. So why wouldn't you go see a lawyer if you can't afford one, which is usually the reason why many people take this path? You should go talk to legal aid, see if you visit their offices, they will check to see if you qualify to be represented by them, and then you can have proper representation. Or you can talk to some firms and explain your need. There are many lawyers who are willing to take on cases on a pro bono cases that is free of charge. You might have a situation where they ask you to pay just for the filing fees, and then they give you their service free. There are many ways around this, but by all means, Madame Anonymous or Mr. Anonymous has to see a lawyer or somebody who understands the processes.
There's no name attached.
Yes,
that should tell you the emotional depth involved.
Yeah.
Because she doesn't even want to be identified.
Our advice said that you should see a lawyer. You see, there are instances you go to a law firm, you tell them now, I don't have money, but these are the properties involved. When we finish the case, you'll be entitled to ABC. The lawyer will look at it and say that, okay, for now I'm not charging you legal fees, but when we finish with the case, whatever you get, I'll get a percentage of it. So
she might lose everything if she doesn't get the right person to support her.
And you know that children are involved, and then the best interest of the children, you don't know what the court will look at to grant you custody. The lawyer will advise you certain things to do. Yeah. There are a lot of things the lawyer will advise you. For instance, if you are the one paying the school fees, you might think they are your children, you are not keeping receipt. But the lawyer might need the receipt. He will tell you that you need the receipt, you need this. For instance, if you are talking about maintenance, I always tell the women that maintenance involves a lot of things. So I'll even ask you to tell me how much you spend on charcoal, how much you spend on firewood, how much you spend on gas, everything. The shoes.
Those ones, we can put figures on them.
Yes, so
no charcoal seller gives out receipts.
Yes, I know, but I mean that your monthly expenses. Your monthly expenses, the judge will not ask you to bring evidence, but you need to put figures on it to be able to present a good case before the judge.
Actually, the judge might require evidence by way of the affidavits of means to show that this is what you spend and this is what you earn.
You know, sometimes practically, I think they want custody because they want to use the children as a conduit.
When you say they, who are you talking
about?
The
women.
No, I mean men also apply for custody.
From my experience.
Men also apply for custody, and some men could also use the kids to get maintained.
Yes.
So don't say the women.
Oh, there's
That is
an
not
instance
common.
I've
That is
gotten
not
maintenance for a man because the
In
woman
Ghana?
was
Oh,
Yeah.
then,
the woman was
then we
earning
are
so
moving
much.
forward.
Yeah, and there are
Yes.
men now counter petitioning for women's property acquired during the
In
marriage.
Ghana?
Yes, I have done that
Then
too.
we are waking
so,
up. We are waking up.
Oh, I got the maintenance for the man
Oh,
because
yeah,
the man doesn't
I mean,
have
the way
so
you're
much.
excited
Oh,
about
that's the
it,
plus,
you didn't
because-
even believe that should happen.
No, because
Yeah,
of the
I-
small ego of a black man, we don't do that.
I told my client that it is, but let's try it, and we tried it,
And it worked. Yeah.
The judge asked that we should file affidavit.
The
of
law
me.
is fair.
Yes, the law
And
is
I
fair.
mean, if the man was dependent on the woman who
Yes.
probably earns more, you're allowed to apply for maintenance
The
to
woman
sustain
earns in
yourself and
dollars.
put, you see, and put
Uh,
body and soul together. So
the-
let's get the next question.
What key factors should individuals consider when deciding whether to represent themselves in court? Are there certain types of cases or legal issues where self-representation is more feasible or advisable? Additionally, what are some common challenges that self-represented individuals may encounter, and how can they navigate these challenges effectively? This is Victoria from West Legon.
It's like Victoria wants us to take her to law school,
Yes.
but that's not the purpose of this show. We're supposed to stimulate the conversation and also get you to know where your rights accrue so you can talk to a proper professional to help you. But perhaps you may have a few words for Victoria, regardless.
Victoria, you don't know, the factors that you need to consider is that the rules of the court you are not familiar with. The law as to how you should even catch your relief before the court. The facts on which you may present your relief is also another factor. Yeah. So you do not know all these things. So these are the factors that I will advise that it is not in your benefit to look at it, to go to court by your own self. Yeah. But the advantages, as we have said, that you get to present your own case, you get to have your emotional, they are minor as to the substance of the case itself. The substance of the case is what you want the court to do for you. On what legs are you standing on to approach the court, and what are you asking for? There are instances the court, even involving lawyers, have even said that the lawyer did not ask for the right remedy. So that is why he got what you got. So I think that it is better to seek a professional advice at all times when approaching the court.
I think I have nothing useful to say because he said it all. The way she went about it, it appears she wanted everything. She wanted to know in what kinds of cases can you represent yourself.
Yeah.
My advice is that there's no small case that goes to court. Any case that goes to court is a big case because you may start from a district court yet you end up at the Supreme Court. So this is a Madam or Mr. Victoria. Just as my brother said, look for a lawyer. You'll get some advice on this.
We could never exhaust this topic because there's more that we are yet to cover. But of course, we have constraints of time. But we tried our best, right, to stimulate the conversation, to keep it going wherever you are. It's been another enlightening conversation on Law Express today. Thank you so much, Theophilus Donkor and Mr. Xavier Kudzi, for being my co-panelists on the topic of self-representation. We'll keep the conversation going. Probably we might revisit this topic again because I feel like we just scratched the surface. There are more aspects to it, but this was all time would allow. My name is Noella Seydu, and this has been Law Express.